I love Titanic, this movie, for three reasons. One, for the classic cult love story, for the sheer cinematography, and for the minute detailing. You remember the scene wherein the lead, Kate Winslet, or the character Rose, because she did not want to marry the fiance in that movie, Mr. Hockley, she was committing suicide. And that very moment when she was trying to jump off the ship from the back, that very instance, Mr. Dawson, or Mr. The character, Mr. Dawson, he just comes in and says, don't jump, and somehow convinces her to just come back. Eventually, he is invited on dinner. If you notice that dinner scene, while they walk in, the elite business class there, while on the dining table, with a lot of romance, a lot of, amidst a lot of leisure, food, they're talking about one law, which is Sherman Act. So just to tell you, Clayton Act and Sherman Act were one of the first few legislations which were enacted in the United States for competition law. In 1700s, there was a mention about antitrust law in the Wealth of Nations book by Adam Smith. In that book, he says that among the business community, the businessmen, the industrialists, they should come together. They form in industries, they form in various associations. Usually these associations must be formed to promote the growth of industry, to promote to promote equality in the industry, or for the promotion of the industry as a whole. But what used to happen is these people used to form trust, and eventually they used to conspire against the public. So the stories of cartels, collusions, these were very these practices were prevalent earlier. And eventually the competition law, antitrust law, so a lot of people call it as antitrust law, and US antitrust laws. So these laws were brought in. The first legislation in United States came in early 1890s or so. In fact, even the proper legislation in the United States came in 1913, 1914. In India, the first competition law was enacted. The proper competition law was enacted in 2002, which became effective in 2009. Before that, in 1969, we were just stopping the monopolies, which is just a part of it. So 2009, in India also, competition law came into effect. Broadly, across the globe, in majority of the jurisdictions, the focus areas, they do not change. In competition law, there are three fundamental focus areas. One is anti-competitive agreements or anti-competitive agreements in India, which is covered in Section 3. Then we have Section 4, which provides for prohibition on abuse of dominant position. And then the combination regulations, or for the gravity of conversation, let us call it as mergers and acquisitions. These are the three matters which are governed under Competition Act 2009. Now, in today's session, because in the previous video, Sarang had commented that next video should be coming on Competition Act, and only for that, to honor that request, I am making this video. Now, today's session, we will be talking about various things which are insightful, and probably a lot of people don't know about it because these things are not talked about often. Okay, so probably we are going to discuss about those things. Anyway, we have just Titanic. We were talking about Titanic, and then we are talking about competition law now. So that is the beauty of that movie, that it was all about cult love story, spanning age, drama, and eventually that the entire. Of course, we all love it. Anyway, coming back to competition law. Competition law across again, I'm at the cost of repetition, I must say that those students who are looking forward for global career know one thing, that you go to EU or Europe, you go to USA, Australia, Singapore, Malaysia, all the jurisdictions, fundamental law remains the same. Now, I was fortunate to have done one course, and eventually for 6 months I was empaneled as a resource person with Competition Commission of India for Maharashtra and Chhattisgarh. So one thing that I can tell you is, the future of competition is really, really bright. And today's session, today probably I am addressing to CS executive students, because you now have competition of a 25 marks, which was quite anticipated by us. And for chartered accountants also in CA final, they have a small part on competition law. So let's talk about it. Now, number one thing, why is why the penalties in competition law are so draconian? Why the penalties which are levied by Competition Commission of India, which is the nodal body in India which regulates the competition, why the penalties are so deterrent? So to understand that, you must know few things. How the investigation goes on, which are the critical matters, which are the relevant matters. Let's just talk about it. And eventually, later on, in some other video, I can talk about things in minute detail. Number one, the growth of any country depends on three factors. This is a study by one of the global cooperative body, which is OECD. Now, what it says is, the report says that growth of any economy, it depends on three factors. One, the resources that the country has got, the competition, level of competition in that country, and the third is innovation. Now, in the less developed countries, the growth of the economy is more so dependent on the resources of the country, less on competition, less on innovation. As you move to the more developed jurisdictions or to more developed countries, now what happens here is the growth of economy is more dependent on competition and innovation, less on the physical resources of that country. That only means that the economy grows because of three factors, wherein for a developing country to become a developed country, or for a developing economy or a less developed economy to become and to navigate through this path and to become a developed economy, one factor which becomes one of the most important factor is competition, the level of competition in that country. I have also mentioned the figures, you can check it out. Also, now what happens is, let me just give you one example. Now, why is competition important? Why this law has been, why the competition law is so important? Let's just talk about it. Now, what will competition do? Now, naturally, this phenomenon, this pratispardha, or this word, this expression competition, is coming from economics per se, right? Now, what happens is, what will competition do to the businesses? How will it affect the consumers per se? How will it affect the economy as a whole? Now, what happens is, what are the benefits of, let's just talk about the basic stuff, everybody knows it. What will competition do to the consumer? Probably the consumers will have more choices at lesser prices. For the consumers, more competition would mean more choices, less prices, better service standards, better post-sale services, right? Just look at this. One new entrant came in telecom industry. Even the BSNL reduced its price. So what has happened after Jio has come in? What has happened after Jio was launched and they had priced it less earlier? You have seen the entire growth has happened in the telecom industry. Thankfully, the internet speed, the cost at which people have access to data has significantly reduced. This is just one competitor coming in, the sector completely gets altered. So for consumers, if I was paying 1,500 for my internet charges or my normal cell phone bill, now I'm only paying 600-700 rupees. Earlier, the internet used to cost me a little more. Probably it is half of what it used to cost me earlier. This is just one example. So telecom industry completely changed. Now, this is just one factor. No, it will have a snowball effect, right? So many services, post, internet and data has become, less costlier, or probably people have more access to it. See how the economic, the e-commerce sector has grown in India. The students, they did not have access to fast quality, fast video streaming facility. Now everybody has that. This is just one example. What happened 2000, 2007, 8, 9? Only Samsung and Apple were ruling the industry. At least full screens, only Apple and Samsung were there. Now for a good phone, whether iOS or Android, they had to shell out 20, 25,000, 30,000 rupees. Now, though I don't endorse any Chinese phones or a lot of other phones which everybody is using these days, I'm still a fan of somebody or the company which comes up with an innovative product or a novel product first, maybe at a higher cost. But see what has happened. Because a lot of phone companies, a lot of mobile phone companies, what has happened now? The phone has become more accessible. Maybe personal choices will vary about what phone is better, what is not. But the thing is, the consumers at large, they have got more options. Probably Apple and Samsung have also come up with a lot of phones which are not that costlier, and they will have to do that. This is just one example of how competition can completely shake up, right? So now, coming back to the statistics, for a less developed country to navigate through the path of developing country and then become a developed economy where the per capita income or the per capita GNP is increasing, or is coming to that level, more than $17,000 per capita. Per capita GNP is coming more than $1,700. So the competition has to be there. If there's no competition, probably the underdeveloped countries would never be able to grow. That means anybody in the country who is hindering the competition, who is indulging in anti-competitive practices, or who is coming between competition, is no less than enemy for the country. It is anybody who is trying to reduce competition or trying to eliminate the competitive practices is almost, it's economic terrorism. So many companies have been penalized. Cement companies case, 6,700 crores penalty to 13 cement companies, one cement manufacturing company. Coal India Limited, 17,073 crores. The case started from Nagpur. DLF, single largest penalty, 630 crores. Why I usually talk about DLF a little more is because they went to Compat and eventually they went to Supreme Court, and eventually Supreme Court, or Honourable Supreme Court, has also held that they have to pay the penalty and they were guilty. 630 crores. Now, in which law in the country you have heard about these sort of penalties, such deterrent penalties? Now, why government is levying so much penalty is because anybody who intervenes, anybody who interferes with competition, anybody who tampers the conditions of competition in the country is not causing harm to a single party. It is causing injury to the entire economy. No single party is being harmed. Now, laws usually, as we all know, the dispute could be between two parties, or then the second could be, there are two systems of law, right? Adversarial and inquisitorial. In adversarial, there are two parties. So one party has caused harm to one single party. Whereas when we talk about competition law, we are talking about inquisitorial system of law, wherein your action is causing injury to the economy as a whole or to public at large. Why, you might have, seen this amazing movie, Jolly LLB versus LLB versus State, yeah, State versus Jolly LLB. Now, why in criminal cases we always say that it is the State versus Jolly LLB or Jolly LLB versus the State? Why do we say that? It's because when one person commits a murder in Nagpur, a few years back, one child one 7-8-year-old child was murdered by a neighbor. So when there's a murder, you're completely, destroying the social fabrics. Now, no neighbor would send their child to, people who are staying around. One murder is not injury to the one person or to one family. It is the murder of entire brotherhood. So in criminal cases, it is always versus the state or state versus the party, right? Because crime can terrorize the entire society. Likewise, in competition law also, if somebody is indulging in anti-competitive practice, it is not causing harm to one party, it is causing harm to the public at large, economy as a whole. For instance, what has happened in cement companies case? These cement companies, they were acting in collusion. There was a cartel. In Hindi, it is called as Gadbandhan. So there's a cartel between 13, 14 companies, There was a cement manufacturers association. They were deliberately reducing the production of cement. Janbujkar. Deliberately the cement production was being reduced. They were creating artificial scarcity of cement. Eventually which would result in increased prices per bag of the cement. Now because these competitors who should have competed, which the competition probably would have brought a lot of efficiencies in the businesses, a lot of efficiencies in these companies. Prices would have gone down. Now when these cement companies are colliding, they are acting in collusion, the prices went up. Now what happens when the cement prices goes up? My cost of living, this real estate, building banana महंगा हो जाएगा, road banana महंगा हो जाएगा, warehouse banana महंगा हो जाएगा. That means the vegetables, fruits would be more costlier, things would be more costlier because transport, road बनेगा तो road का toll लगेगा ही लगेगा. Road का cost government के पास जाएगा, government को देना ही पड़ेगा. Now at the end of the day, who's the government? We the people are the government, right? पैसा तो हमारा है ना, टैक्स पेयर का है. तो सीमेंट महंगा हुआ, रियल एस्टेट महंगा हुआ, कंस्ट्रक्शन महंगा हुआ, हिंदुस्तान का इंफ्रास्ट्रक्चर बनाना महंगा हो गया. Already you all know that the infrastructure sector needs the push. Now सीमेंट बैग महंगा होने से सिर्फ एक पार्टी को नुकसान नहीं होता, पूरे कंट्री एज अ होल को नुकसान होता है. And that is the reason the penalty was so deterrent that it was 6,300 crores, 6,700 crores, unheard of in India. With this judgment, Competition Commission of India just arrived. And all the corporates, they started preparing. What are the measures which they have to take? They started internal audit, competition compliance programs were going on. All the big corporates, they hired these law firms. These law firms were conducting, they were waiting the contracts, or they were trying to check whether they are doing something bad because the cost of not behaving is too high. Coming back. Now, I hope you understand why competition law is more important. I hope you understand why the penalties are so deterrent. So one is, we're talking about a law which is inquisitorial, system is inquisitorial. एक पार्टी की वजह से दूसरी पार्टी को हार्म नहीं होगा, पूरी कंट्री को, पूरी इकोनॉमी को हार्म होगा. Secondly, just few more secrets. It's probably not covered much in any module. I've just seen the modules. Now what happens is, in competition law, in Competition Act, we don't use the word complain. We use this expression information. Now what happens is, in competition law, here जैसे हम लोग पुलिस, जब कोई क्राइम होता है तो हम पुलिस के पास जाके क्या करते हैं? FIR करवाते हैं. What is FIR? First information report. We just inform the police. Investigation is task of police. Likewise, when something goes wrong, we just have to inform the Competition Commission of India. The word complaint is not used. The word or the expression which is used is information. The word is not complaint. It is information. Because we have to just inform the Competition Commission of India and rest the investigation, fact-finding, analysis. It is the job of the commission. They will take cognizance, they will do the needful. So what happens is, here the investigating body, the regulator, the adjudicator is going to actively participate in fact-finding analysis. Right? And the nature of crime is such that it is very difficult to find out the evidence is, right? So that is the reason sometimes there are two rules which I use in this law. One is per se rule, wherein the regulators, the adjudicators, they use presumptive approach that, okay, if few things are proven, we would deem that there is something wrong. Now what happens here is, there are a lot of instances where the Competition Commission of India has relied on circumstantial evidences, because अगर कोई 4-10 सीमेंट कंपनी साथ में मिलकर अगर कोई कॉन्स्पिरेसी कर रहे होंगे, जानबूझ के सीमेंट के प्राइसेस खुद से बढ़ा रहे होंगे, तो क्या वो लिख के एग्रीमेंट करेंगे क्या? So the definition of agreement in Contract Act is completely different. In Competition Act, the definition of agreement is completely different. So the agreement need not be formal, the agreement need not be, in writing. So what happens is the definition in both the acts will differ. So यार मैं ये बताना चाह रहा था कि in Competition Act penalties क्यों ज़्यादा लगती है, क्यों हम लोग बात करते हैं information की, और क्यों हम लोग complaint word का यूज़ नहीं करते. तो what happens here is, in many, especially in the cartel cases or in bid rigging cases, now what happens is, जहाँ competitors साथ में मिल रहे हैं, horizontal agreements हो रहे हैं, anti competitive agreements में जब कोई horizontal agreement कर रहा है, section 3 में जो आता है, section 3(3) में जो आता है, जब horizontal agreements होंगे तो the standard of proof is not beyond reasonable doubt, it is preponderance of probabilities. That means we will rely on the circumstantial evidences also, because we know that अगर कोई कार्टेल बनाएगा तो वो लिख के थोड़ी बनाएगा. अगर कोई पब्लिक के खिलाफ कॉन्स्पिरेसी कर रहा होगा, जानबूझ के प्राइसेस बढ़ा रहे होंगे, तो नेचुरल सी बात है, कोई लिख के थोड़ी करेगा, कोई फॉर्मल अग्रीमेंट थोड़ी करेगा, राइट? सो इसीलिए कॉम्पिटिशन कमीशन ऑफ इंडिया ने सर्कमस्टेंशियल एविडेंसेस पे भी पेनल्टीज लगाई है. आई होप यू अंडरस्टैंड. So we just wanted to talk about it now. Just briefly, I will introduce about this entire chapter or entire act, and we'll wind up very soon.